Good morning and welcome to All Things Marcellus with me, Attorney Doug Clark of the Clark Law Firm. I am here with you every Sunday from 8 to 9 a.m. on these stations to bring you, the landowner, the valuable information that you need regarding natural gas development here in Pennsylvania. And of course, and as always at the Clark Law Firm, my focus is solely only on landowner and oil and gas right owner representation for such items as gas leases, reviews, negotiations, consultations, pipeline right-of-way agreements, well site agreements, damage releases, water impoundment ponds, compressor stations, meter sites, roadways, well pad agreements, surface use agreements, you name it, we take care of it. That's what I do, represent landowners, only landowners. And of course, I have not, will not, and do not, but will not represent oil and gas companies. I represent Pennsylvania landowners and oil and gas right owners. So if you do need representation, you want to learn more, we have clients all across the state of Pennsylvania and clients who currently reside and many clients who have resided across the country and even in other countries, as long as that property or gas rights are being held in Pennsylvania. So don't ever be afraid of distance. Give us a call. I'm sure we can help you out. Our number is 570-307-0702. Again, that's 570-307-0702. If you're looking for landowner representation, I'm very confident that we can help you out. Again, it's what we do. But also, if you're looking for representation, you want to learn more, or you're looking for high quality landowner information, check out the websites. Again, whether you're just looking for information, pagasleaseattorney.com, pipelineattorney.com, ton of great landowner information there. Use it as an educational resource. Use it to learn more about the Clark Law Firm and what we do. But make sure you check out pagasleaseattorney.com and pipelineattorney.com if you want to learn more about the oil and gas industry and landowner issues in Pennsylvania. Also, quick reminder, I've been doing the radio show since 2010, and we recently started broadcasting in southwestern Pennsylvania. We're broadcasting in north central and, of course, northeastern Pennsylvania. And I want to encourage everybody, you can go to the websites and listen to prior radio shows. So if you're interested in leasing, if you're interested in pipelines or selling oil and gas rights, real estate transactions in the oil and gas industry, you name it, I'm sure there's a show that you're going to find up there, pagasleaseattorney.com, pipelineattorney.com, and we'll get this show up and available. The one we're running here today will be up and available on Monday. Should be up there Monday morning. Okay, so let's jump into it here. What I want to talk about today is, in the first part, and we'll see how long this goes. I get these kind of outlines together, but I don't always follow them, as you know, if you're a regular listener. But today, one of the things, I meant to talk about this some last week. I started to touch on it. But one of the things that we're seeing now is, I've been talking a ton about the low gas prices and the impact that it's having on natural gas companies. And how, despite what you may think, this low gas price market can be a real opportunity for you as a landowner. Doesn't seem to make sense. How can low gas prices help me as a landowner? Well, people who see the royalty checks and see how small they've become because the gas prices are so low, and the companies in many cases have stopped or reduced or limited production, so they're seeing super small royalty checks when they may have seen much larger royalty checks in the past, and they're saying right now, that guy on the radio is nuts. What's he talking about this being an opportunity? We're getting killed. Yeah, that is 100% true. Low gas prices are deadly, if you will, to royalty checks, because you're going to see if gas is being sold at $1 a unit. Well, if it was sold at $5 a unit, that would be 5 times the money. So when you're selling gas at $1 and less than $1 per unit, well, those royalty checks aren't going to be that big. Also, you're seeing companies scale back or reduce production. So you're getting the deadly double whammy where gas prices are super low and companies aren't producing much. So if they're only producing 1,000 units in a given month and selling it at $1, that's $1,000 in revenue. But if gas prices jumped up to $5 and then they say, well, let's produce 10,000 units, well, that's $50,000. So there's obviously a huge difference there. So what we're seeing is low gas prices are really hurting landowners who are in the royalty phases of their lease. But because of these low gas prices, I just touched on companies scaling back production. Well, when you scale back production, not only are they just scaling back wells that are already drilled and producing, but they're stopping or greatly curtailing their drilling program. But in many cases, stopping. Companies don't want to drill. Decisions have been made at corporate levels, and I talked about this recently. They've been made at corporate levels to stop or drastically reduce drilling, but in many cases, stop drilling in Pennsylvania. Well, what does that mean? Well, how do I say, or what does it mean when you say that might be an opportunity? That doesn't sound good. Well, it doesn't. It's not good to get royalties, but where this is coming into play and giving landowners opportunities, and unfortunately, landowners aren't realizing this and aren't getting good information and don't understand that, hey, wait a second, let me take a step back and see, wait, can I do something about this? And what am I talking about? Well, when you stop drilling as a company and you have leases that are out there, that are active, that you've secured yourself, or maybe you inherited by a transfer or an assignment from another company, well, if there's no wells drilled and there's nothing going on, you have a time limitation. There's a time frame on that lease, usually 5 years, but absolutely could be 10, could be 8. There can be other extensions and things in the lease. But if you have a lease as a company, you need to do something by the end of that initial lease term in order to hold the lease so it doesn't expire. You're listening to All Things Marcellus with me, Attorney Doug Clark of the Clark Law Firm. Remember, I'm here every Sunday from 8 to 9 a.m., and you can go tomorrow, check out today's show, pagasleaseattorney.com, pipelineattorney.com. Okay, so what we're talking about, by the end of, let me back up. If you sign a 5-year gas lease, many people have signed a 5-year gas lease with a 5-year company option to extend the lease, so it becomes a 10-year lease, if you will. But when we talk about a 5-year lease or a 10-year lease, there's still a lot of confusion out there. A lot of confusion. We need to clear it up. It's real basic. What happens is you have a primary initial term, whether it be 5 years or 10 years, or maybe it's 5 years and the company is allowed to extend it an additional 5 years, but that is called your primary term, your initial term. Company has to do something in order to extend the lease beyond a 5-year term. Many people, unfortunately, think, and I just talked to a lady this week, wonderful lady, spoke with her. She thought that she signed a 5-year lease and she thought her lease would expire in 5 years. But the company did something within 5 years. And when you do that, when a company conducts operations, which are defined in the lease, if they conduct operations, which isn't always just drilling, many times it can be simply filing a permit, but they have to do something in order to hold the lease beyond, say, the 5-year term. So the 5 years is a test, if you will. It's a test for the company. What have you done at the end of 5 years? You look at what the lease says, and the lease may say you need to file a permit and start constructing the pad and do what's called continuously operate, meaning you can't start the pad and then leave for a year or two and then come back. You have to start the pad, and then usually there's language in a lease that'll say that you can't have gaps in operation of more than 90 days. That's a common term, not always, but a very common term. Some say simply due diligence, meaning you can't go out, construct a pad, and then leave for a long time. You have to continue to operate with due diligence. That's kind of a gray area, but still, companies seem to like to keep that 3-month test, that they're not inactive for 3 months. Due diligence probably allows them to be inactive a little longer than that, but companies generally want to be conservative. So let me circle this around. So the key point here is that the company must conduct operations within that initial term of your lease. If they do, then the lease extends indefinitely as long as there's gas produced or capable of being produced. Very tricky stuff there. So if they drill a well and they cap it, that well is sitting there, that's not producing gas. They may not even have it connected to a pipeline, but that well is capable of producing. Capable because there's gas in it. It's ready to go. They just haven't connected a pipeline. Then usually, I'm not going to go too deep in this. There's other language that says, okay, if the company does that, that would be what's called typically a shut-in well, shut in. So then they have to pay you usually $1 to $5, sometimes more per acre. Well, that well sits there capable of producing, but not actually producing. So that's an example, but what I want to again go in deeper and explain this. So what are we talking about? How am I saying these are opportunities? Well, here's what's happening. You're finding in areas of the state, and it just so happens again that a real common area today, but it's occurring other places as well. But Tioga County today, tomorrow, and over the next year and even two, has many leases that are expiring either because the person entered into a 5-year lease and it's about to expire, or they entered into a 5-year lease and the company had an option to extend the lease for 5 years, and now the 10-year time has come up and then it's going to expire. And so in other cases, and this is very detailed, you find leases, especially in this Tioga County, that were entered into with East Resources back in the 2000s, like 6, 7, 8, 9, in that type of range. Well, many of those leases have language that says, and it's a Pugh clause, but what it says is, well, if you only drilled to a certain depth, so say, for example, you've only drilled as a company to the Marcellus Shale Formation, well, if you've only drilled that deep, any acreage or property or deeper formations, Utica, is no longer under lease. So what do we have? What am I saying here? I'm going to try to wrap it up here quickly, and we'll summarize again at the beginning of the next segment. But the point is, the company, remember, has to do something in order to hold the lease. Something is conduct operations. Operations may be simply filing a permit, but you have to follow up on that permit. You can't just sit there, file a permit, go recline on your recliner for a couple years, and then come back. No, you have to do things. And what are those things? Well, ultimately, you're going to have to drill, ultimately. So that's where the rub comes in. You ultimately, as a company, are going to need to drill to hold leases. However, corporate offices in Texas are saying, Oklahoma, hey, no more drilling. It costs too much money and we can't sell this gas for a price that we're going to make a profit. So there, my friends, is the landowner opportunity. There we've identified the landowner opportunity. I'm going to explain it in detail after this break. You're listening to All Things Marcellus. I'm here with you every Sunday from 8 to 9 a.m., and I'll be right back after this break. Welcome back to All Things Marcellus with me, Attorney Doug Clark. I'm here with you every Sunday from 8 to 9 a.m. to bring you, the landowner, the information that you need regarding natural gas development here in Pennsylvania. Okay, so I'm going to jump into this again. Now, let me just say, like, some of this stuff gets confusing. So, again, I welcome you. Go back on Monday morning. We'll have today's show. We'll post it up. You can go back and listen to it, rewind it. I don't know if you rewind anymore on computers, but you can go back, fast forward, I guess it's rewind, and listen and catch this stuff, because I know it's tough sometimes when you're getting a lot of information over the radio. You know, you hear it, it's gone. No, we have it. It'll be up on pagasleaseattorney.com, pipelineattorney.com. It's not going anywhere. Access it anytime at your leisure. Okay, so this is all, stick with me, because this is all going to really circle around of something that I want landowners to do in order to help themselves. And here's what I mean. So let me fix this and summarize this from the first segment and try to pull this together. All right. The point of this is, Low natural gas prices have resulted in companies reducing or stopping drilling, that they're not drilling wells in Pennsylvania in 2016. Several companies, many companies, they're not drilling. So I said that gives landowners an opportunity. Now, it doesn't give landowners an opportunity who have wells drilled that are getting royalties. They're saying, boy, I want these natural gas prices to rise, so I'll get more royalties. Common sense, absolutely correct. Low gas prices, not such a great opportunity for you if you're receiving royalties. However, many people have leases that are on the verge of expiring. And when I say that, I don't mean expiring tomorrow. I'm talking about at the end of 2016 or even 2017. In some cases, 2018. That's a couple years out. So we're seeing leases that are not just expiring tomorrow or in the next month. Sometimes that's the case, but over the next couple years. So the lease, all these leases, very common mistake. You enter into a 5-year lease or a 10-year lease or whatever that time is. The company has that time, 5, 10 years, whatever the case, to conduct operations. Operations is the key word. I did a big, long blog about this on the website, pagasleaseattorney.com, pipelineattorney.com. Go check out the blog. Excellent. Well, I wrote it, so hopefully it is. Well, maybe you'll find it not, but I think it is. Excellent information about this, about operations, what has to happen. So, company has to conduct operations. Operations at some point in time, not right at the beginning. So if you have a 5-year lease, it doesn't mean the company has to drill a well in 5 years. Very, very, very rare. So what do they have to do? They have to conduct operations. Operations is defined generally in your lease. So you'd have to pick up your lease, read it, and figure it out. And that normally is something along the lines of filing for a permit is kind of the easiest thing for the company to do. But after they file for a permit, they still have to continue to operate. You can't just file for a permit, go sit back, relax on your recliner, wait a couple years as a company, then come back to start to do something. You're ultimately going to have to start drilling at some point. So companies recognize low gas prices. We have all of these leases out there that are going to expire over the next year or two. We're having a directive from Texas, Oklahoma, wherever, saying we're not drilling more wells. So what do we need to do? We're not going to be able to hold on to these leases that are on the verge of expiring, not just in 2016, but 2017, 18, in some cases beyond. So what do we want to do? We can't drill because we don't have the resources, and we have a directive from the company saying no more drilling. So what do we need to do? We don't want these leases to expire. In many cases, the leases that are on the verge of expiring are pretty company friendly. So they don't want those leases to expire. They want them to continue onward. Well, how do you do that? Well, you have to conduct operations. You have to ultimately drill. Well, company doesn't want to drill. Company has a directive. We're not drilling new wells. Now what does the company do? Well, they have a problem. So how are they addressing this problem? Well, they're going out to landowners to extend and modify your lease, to give themselves more time to drill years into the future. That, ladies and gentlemen, is a potential outstanding opportunity for you, the landowner. I have talked a lot about this over the past several months. I probably will continue to talk about it. I've beat this subject in and out so many times, and the reason why, especially Tioga, Lycoming, North Central Pennsylvania especially, but this can apply other places as well. Please, ladies and gentlemen, if you're asked to extend or modify your lease, get help. You can call us 570-307-0702 or somebody, but get help. This can be an outstanding opportunity for you. Just this week, client this exact situation. We did a review, a consult, got a plan together, and sure enough, instead of the offer to extend that was going on, they're going to do much, much better. And they understand their rights, they understand what their options are, and it's going to work out very well for them. Or they could have just simply signed and missed out not only on money, but serious property protections that they didn't have, but now that we've been able to secure. So very, very important. You got to get help on these issues. And why? Why? Because the landman works for the company, not you, the landowner. You as a landowner need to have, in my opinion, especially in these type of matters, somebody working for you. You cannot, common sense, how do you rely on an employee of your adversary? Because this is an adversarial negotiation. Not adversarial that you're going to punch each other in the nose in most cases, but adversarial in that you're negotiating a contract that you want to be better for you. They're negotiating on the company's behalf a contract that they want to be better for the company. It's just common sense. When you go into a car dealership to buy a car, you're trying to get the lowest price. And the salesman is trying to sell you the car, but she wants to sell it to you at the highest price. It's common sense. We need to use common sense. And in these matters, when you're not experienced and you don't have that history, I don't care if you did your first lease, your neighbors did leases, you study this stuff. I'm telling you, I do it every day and I learn things every day. I do it every day and I learn things every day. There are so many small nuance issues and just minute things that have a tremendous impact. And that's where you need to get, as a landowner, some independent assistance from somebody that knows what they're doing and is going to help you. So whether you call me, 570-307-0702, or someone, I say it all the time, and I do mean it. We got to stop this. We have to make sure that landowners aren't signing extensions of bad leases for little or no compensation whenever there is much more opportunity that may be available. We got to learn, understand what that opportunity may or may not be, and then make a good decision. And those type of decisions can be worth tens of thousands, literally hundreds of thousands, and in some cases, depending upon the acreage, millions of dollars. You're listening to All Things Marcellus with me, attorney Doug Clark of the Clark Law Firm. I'm here with you every Sunday from 8 to 9 a.m. So, okay, as always, I get a little off track sometimes. But no, super important information. Everybody, super important information. So what I want to also talk about then, so let me back up. When you have an extension and modification, you need to put it down and get information. So when I talk about this opportunity, the opportunity is that the company, and you need to know this, and this is public available information, what the budget is, what the company intends to do in drilling in Pennsylvania. And if we know the company's not going to drill any wells in 2016 and your lease expires in 2016 and the company comes and offers you an extension, well, we can understand and assess your leverage and say, hey, maybe you're going to be better off to let this thing expire. Or you understand your leverage and you're going to negotiate and get additional royalty. Maybe get a provision that will eliminate or reduce deductions for post-production costs and transportation fees. Maybe you can get that. Maybe, in one case we worked on, the original lease allowed for operations on the surface of the property, negotiated and said, hey, if we're going to extend this, maybe we'll do it. We want some more money. Maybe we want this, we want that. But one of the other things we want to do is say, well, we extend this lease, we want to say that the new lease won't allow any operations on the property. So you can't put a pad on my property. You can't put a roadway. You can't put a pipeline or anything else. Well, if you're going to give me that, then maybe I am inclined to go ahead and extend my lease. There are many different options. Maybe it's just about money. Maybe it is, hey, you know what? My old lease is really bad, and I want to get some additional terms added to it. So maybe you do that by way of an extension or modification, and you negotiate it. Or maybe you say, hey, I'm going to let this lease expire. I'm going to wait until the market improves some. You want to have some fun? Here's a great thing. Landman comes out, says, oh, we don't have any money. No one has any money. Gas prices are low. No one has some money. Again, hey, there can be truth to that. So they say, this is all we can offer you. We don't have any money. Maybe they're offering you a 5-year lease. Maybe they're offering you a 10-year lease and say, we're going to give you this money. We don't have any money really, but we're going to still do this. This is tough. This is amazing that we're giving you this money, but we want you to sign this 10-year lease. Well, okay, how's this question? Well, what if the gas prices go up by 2, 3, 4, 5 times in 2 years from now? So we fast forward, I signed a 10-year lease today, 10-year lease, which remember I talked about operations means that by the end of 10 years, maybe the company simply files for a permit, they use continuous operations, takes them another year to drill. Then from there, they shut the well in for 3 or 5 years. Well, now 10 years plus a year to drill, plus we'll say a 3-year shut-in, that's 14 years, and you haven't seen a dime of royalty. So ask yourself, and this isn't specific advice for anyone, but ask yourself, why do I sign a 10-year lease today where there's no obligation for the company to do anything but file a permit within 10 years whenever the gas prices are so low today and the company tells me they don't have money. Their budget is gone. They don't have money. Gas prices are low. Well, then, company, if gas prices rebound and go up, which many, many people think they will, nobody knows. Many people think they will. I think the industry thinks that they will. So if the gas prices go up, say they go up by 5 times in the next few years, which is possible, well, then, company, you're going to have a lot more money. So it's going to be in my interest to maybe wait and negotiate whenever you have more money, or, hopefully, and let me back up too, because again, this isn't specific advice, but there may be other opportunities. It could be you wait and there is no future lease, and that's what you got to think about as well, but that's where detailed quality representation is really going to help you. But my point is, to close this segment out, the point is this: why, and you should be asking yourself this, why enter into a 10-year lease or a 5-year lease with a 5-year option with a company who's saying, well, we don't have any money and we're not planning on drilling? Maybe, not specific advice, but maybe you might be better off waiting, especially if the current offer is at the 12.5% royalty, which is the lowest allowed by Pennsylvania law, and allows for full deductions of post-production costs. If that's your lease, boy, you need to be thinking about, do I want to extend this? But you need specific advice. This isn't specific advice. This is general advice. But you need to be thinking about these things. Boy, you need to be thinking about it. I promise you, you should be thinking about it. You're listening to All Things Marcellus with me, Attorney Doug Clark. Remember, I'm here every Sunday from 8 to 9 a.m. Today's show will be up and available online at pagasleaseattorney.com and pipelineattorney.com Monday morning, tomorrow, so you can check it out then, as well as hours upon hours of other shows. Been doing the radio show since 2010, and maybe it's good news for landowners, hopefully bad news for companies, but we're not stopping. We're going to keep going. I'll be right back after this break. Welcome back to All Things Marcellus with me, Attorney Doug Clark of the Clark Law Firm. I'm going to jump right into it. Okay, so we're talking about opportunities and what lease extensions and modifications can be for an opportunity, and I've really been beating this for a while because it's so important, especially north central Pennsylvania, especially Tioga County and that surrounding area. Please go back, check out the show. We need to get you this information. But that's not the end of it. I'm talking about opportunities. There's this other hidden opportunity that is crucial and critical, and to my experience, no one's doing it. And I don't care whether you're in southwestern Pennsylvania, north central, western Pennsylvania, northeastern Pennsylvania. Pay attention to this. It's the same type of principle. We have a low gas price situation. We have companies stopping or drastically reducing drilling. That, as I've been talking about earlier today and past weeks and on the blog, go to the website, check out the blogs, that has given landowners an opportunity. The opportunity is that many leases, which nobody ever thought would expire because they thought drilling would keep going, drilling has stopped. So what has happened? Those leases, at some point, drilling has to occur. Since companies aren't drilling, they cannot continue to hold on to your lease. So it's a chance, an opportunity in many cases to get out from under a bad lease and try to negotiate and enter into a better lease, or to wait for potential future opportunities. Not specific advice, but this is what we need to be thinking about. So that's a major, major part of things and a major opportunity for many landowners. However, there's something else that's occurring, and landowners aren't doing what they need to do. And that is notifying the company that either your lease has terminated and you want it off the books, so to speak, or that a portion of your lease has terminated and you want that acreage under your lease that the company can no longer hold. You want that what's called released, surrendered, or given back to you. Now, I'm going to explain this, but the point is, I'm going to start with the kind of the end, and then we're going to explain all the way to get to the end. What we need is landowner lawyers to write certified mail correspondence to the gas companies and notify the gas company that your lease has either terminated entirely, or because you have a Pugh clause or similar type language in your lease, that your lease has terminated, maybe not to all of the property, but to a portion of your property. Let me explain. I've talked about this many times. I'm going to do this quickly. We're going to make it real simple. If you have a 100-acre property and you have a Pugh clause, if you have the purest form of a Pugh clause, and it's spelled P-U-G-H, if you have the purest form, it would say that if you had a 5-year lease, at the end of 5 years, company, if you only have 60 of my 100 acres in a unit, that's all you get to hold on to. The other 40 acres that you didn't place in a unit within the 5-year lease revert back to me, because you haven't put them in a unit. They're not unitized. You get to keep what you've unitized, but what you didn't unitize comes back to me. However, huge however, these provisions generally state to the effect of, upon that termination, that property reverts back to you that's not in the unit, but you have to write the company and request what's called a release of the non-unitized acreage. If you don't write the company, we're not seeing companies release this property. We're just seeing it still being held, if you will, under the existing gas lease. You need to. The lawyers need to. I'm going to scream this from mountaintops. Start writing letters to the company to release non-unitized acreage, which is eligible for release under Pugh provisions in many cases. Very important. If you don't write write the company, we're not seeing companies voluntarily releasing acreage, which is available to be released and returned back to the landowner because of a Pugh provision or something to that effect. We need to take action. Get that property released, let free. So pure Pugh clause, 100 acres, 60 in a unit, 40 out. That clause says, well, if that's what you did, company, what you didn't have or what you don't have in a unit comes back to the landowner. But landowner, you need to write the company and tell them, hey, I have a Pugh provision, paragraph 15 of my addendum, which says blah, 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 whatever it says. And I'm going to ask you, or I'm going to demand, you don't ask, you respectfully demand that the non-unitized acreage be released and that the company file a release at the courthouse. Now, that property is totally free of any lease, and you can enter into a new lease, you can wait, you can do whatever you want to do with it. But you want to cancel out that lease if it no longer applies, certainly to all of your property, but in many cases, many landowners have a lease which has expired to part of their acreage, not all of it, but part of it. And they haven't written the company, and the company hasn't voluntarily or taken action on their own to release or give you back that portion of your property. We need to write letters. You need to write letters. You need to know what your lease says, and then you need to write the letter to the company and say, hey, give me my property back. What's not held under the lease reverts back to me. Now, you got to look at your lease and understand your Pugh provision, but that's what we need to do. You're listening to All Things Marcellus with me, Attorney Doug Clark of the Clark Law Firm. Remember, we're here with you every Sunday from 8 to 9 a.m., and you can go back, check out the show tomorrow, many other shows on pagasleaseattorney.com, pipelineattorney.com. So, okay, I want to go a step even further. So remember, everyone, look, pull out your contracts, look and see if you have a Pugh clause. If you don't, well, this may not apply or wouldn't apply in many cases. However, you still may have the opportunity, even without a Pugh clause, that the company is not going to be able to drill in time to hold your lease. But if you have a Pugh clause, you need to identify it. You need to understand it. And I'm going to tell you, I gave you the most basic, simple, pure Pugh clause language that is out there. Whatever's in the unit at the end of 5 years, the company maintains the lease for. Whatever is not in the unit at the end of 5 years, that goes back to you. But you need to write the company a letter, certified mail. Hey, company, I have this language. You need to file a release. The company then, as long as you're right and you have that language, has no choice. They'll file a release, or they may try to negotiate with you and enter into an extension or something along those lines. Then you're going to look at, okay, well, how good is my lease? What are they offering? What is today's market? Do I want to extend? Do I want it to expire? Do I want to negotiate? How do I want to handle that? And that's where it gets really detailed. Also, the Pugh clause itself can be unbelievably confusing and complicated. I've talked about this. I do this all the time. There's many, generally, a lot of Pugh clauses I have to read at least twice. Many times I have to read them 5 to 10 times because they're that complicated and they're modified in so many different ways. So you may think that you have a Pugh clause that makes you eligible to have acreage released, but you may be incorrect. Or you may think, well, I'm stuck, I'm held, but you may be incorrect, and in fact, you're eligible to have property released. If you have a Pugh clause and you don't know, you're not seeing production, or you're only seeing something on part of your acreage, you need to understand, hey, am I eligible to have property released? I'm going to get commercial for a second. I do these reviews and consultations all the time. Something like this generally takes an hour, most 2. And what we do, you send me the documents, we look at it and say, okay, hey, you have a Pugh clause. Hey, here's what the activity is. Well, it looks like you may be eligible, or you are eligible to have property or acreage released. Or I may say, well, look, hey, worst thing is you get the answer. You don't, it's not the answer you were looking for, but you got the answer. So we do these, and it's generally a very valuable thing. Generally we always get very positive feedbacks. So you can do a review, a consultation, learn about your lease, understand do you have any of this language that may make you eligible to have the property released, and identify it. And do you, don't you? What does your language say? And answer those other questions. So again, because it can be confusing, it is tough when you don't see this language. And like I said, I've read Pugh clauses 5 to 10 times before I've been able to really get my head fully around it. So it can be some complicated stuff. So if you're interested in that, call the office, learn some more. 570-307-0702, 570-307-0702. But hey, look, again, I mean this. If you don't call me, call somebody, but you need to identify, or does your lease have a Pugh clause? Does your lease have you eligible? Are you eligible to have property removed from that lease or released or taken away? You need to do that. And if you are eligible, you need to write, I'm going to keep preaching this, we got to write these letters. We got to get this property released. I've been writing these letters recently and getting property released fairly regularly. It's something that's especially in North Central, but this happens all over the place. And I'm going to go one step deeper in the final segment. Not only, I gave that example of 100 acres, 60 in a unit, 40 or not. A landowner has a Pugh clause, which says what's not in the unit gets back to me, and that's 40 acres in this case. You write the company, hey, I have this language, release this property. They say okay, or they try to negotiate. You could negotiate, or you let it go. So that's one example. That's a pure, easy, simple Pugh clause. Like I said, there's many different modifications, but what I'm going to talk about in the last segment is a depth severance Pugh clause, one that says that whatever, for example, however deep you've drilled, that's all the deeper you can go at the end of that 5 years, and anything below that, we want it released. That is an extremely powerful provision, especially Tioga County today and surrounding areas, but not just that. In general, that's a very powerful provision. We're going to talk about that in the last segment. You're listening to Attorney Doug Clark. This is All Things Marcellus. I'm here every Sunday from 8 to 9 a.m., and I'll be right back after this break. Welcome back to All Things Marcellus with me, Attorney Doug Clark of the Clark Law Firm. I'm going to jump right back into it again here, final segment. So, okay, what I want to talk about now is we've been talking about this pure Pugh clause. Remember, there are so many different types of Pugh clauses, and they can be extremely complicated. But what we need to do from the landowner's side is to identify your Pugh clause, if you have one, to identify what the company has done to date, and whether you have acreage under your original lease that is currently eligible to be released or returned back to you. So if you have 100 acres, maybe 10, 20, 30, 40, 50, maybe even 90 acres is eligible to be reverted back to you, but you have to write the company a letter. So we got to identify this. Are you in this position? And if you are, we got to start getting this acreage released. It can affect future opportunities. We need to take action. The leases require you to take action. You need to identify, do I have this? Does it apply? And what do I need to do? What action do I need to take? Very important. When you're being asked to sign extensions, modifications, changes to the leases, sometimes there may be something more hidden behind this, which may be the fact that you have some acreage that's already eligible to be released. When a company comes to you and says that they're doing you a favor, red flags should be coming up. Red flags should be coming up. So, okay. What I want to talk about now, it goes another step deeper and is right now impacting, I'm confident, hundreds of Pennsylvania landowners. Again, especially a hot issue in Tioga County in that region at the time, but this can apply everywhere. And I'm sure that it's currently applying in northeastern Pennsylvania because a lot of leases have, especially negotiated leases, but a lot of these old East Resources leases have what we call a depth severance. It's a Pugh clause that separates the depth. Very basic example will say, and I stress this is going to be made very easy, but this language can be very complicated. But here's the sum of it. That at the end of the 5-year initial term, if you have a 5-year lease, or if it was a 5-year lease and a 5-year extension, at the end of the extension time frame, so 10 years, some of these get super complicated, and they'll say that, well, at the end of 5 years, if the company did something, they get another 3 to 5 years to include the rest of your property, or what we're going to talk about, to drill deeper into the ground. So what we're seeing is many existing leases have what we call a depth severance provision, a Pugh provision that says two types of ways typically, and again, it can be very complicated, but it'll say, okay, we'll make it simple. At the end of 5 years, however deep you've drilled, company, that's all the further rights you have. So when you enter into a gas lease, essentially a general rule is the gas lease like you're leasing your gas rights, oil and gas rights, from the surface of the earth to the center of the earth. But a depth severance will say, very simple example, well, at the end of that 5 years, if you've only drilled to the Marcellus shale formation, anything below that formation is released or can be returned to me. Again, you have to write a letter to respectfully request that property is returned to you. So what does that mean? Well, what we're seeing is many of these leases had depth severance provisions that say, however deep you've drilled at the end of this 5-year, 10-year, whatever term, that's all the further. So instead of the lease saying from the surface of the earth to the center of the earth, what it's saying is you now are limited, company. Your lease only applies from the surface of the earth to the bottom of the Marcellus shale formation, or maybe only to the deepest depth drilled, which could be interesting because what if they've only drilled to the top of the Marcellus shale formation? So you need to, I can't stress it enough, go pull your lease out. Look and see if you have this language. And you're going to find if you do, almost guaranteed, there's going to be a requirement that you write the company and request that they release or return that acreage to you. You're listening to All Things Marcellus with me, Attorney Doug Clark of the Clark Law Firm, and we're talking about Pugh clauses and releasing of acreage. And remember, I want to just, again, kind of explain this. You have two different ways. You have the idea of, okay, if you have a Pugh clause that says whatever acreage is unitized, that which is not returns to me, well, that means if you had 60 acres in a unit and 40 acres were not, that 40 acres that are not in the unit is eligible to be returned to you. What do we need to do? Write the company a letter, but we can have that acreage returned. So if you have 40 acres in that example returned to you, well, that 40 acres is returned under a standard Pugh clause in its entirety, from the surface of the earth to the center of the earth. But there's another provision which can be much more complicated, which I'm telling you, especially Tioga County landowners, I'm seeing this provision pop up all the time. You have, in many cases, an additional Pugh-type language, which, think about it, like if you can imagine cutting the earth in half from top to bottom, if you do that with a circle, but opposite of the equator, from the North Pole to the South Pole, if you cut the earth in half and see that the company only drilled down wells to say 6,000 feet, or the Marcellus formation, it's at different depths in different areas, but if that's all the further they've drilled, you may have language that says you can't go deeper unless I sign a new agreement or modify my existing agreement. Many landowners are being asked to extend and modify agreements and don't realize that a big part of this is because they have depth severance protection that they have already in some cases, or in the very near future, they're on the verge of having the Utica shale layer and all these deeper formations released and returned to them. Tioga County again. Look, the buzz out there, Utica, Utica, Utica. Well, if you're part of a unit and you have a Marcellus well drilled, then you need to look and say, okay, hey, maybe that's all the deeper they can go based upon my lease language. What do? Write them a letter. Say, hey, company, or have an attorney do it. You've only drilled to the Marcellus layer. Lease paragraph such and such says that at the end of this initial term, you only get to keep the depth to what you drilled to. So if you've only drilled to Marcellus, everything below that reverts back to me. And we know that the companies want to drill Utica out there. So when you're talking about Utica, if you have, where would you rather have? Your existing lease, no additional bonus. Maybe it's 12.5% royalty. Maybe it allows full deductions. Well, if you have this depth severance language and you can release that deeper Utica formation and others, but we'll talk about Utica. Well, what happens then? Well, it's essentially a second lease for your same property. You'll have one lease for Marcellus and above and a second lease for the deeper formations, which could be higher royalty. And hey, they're saying, companies, oh, these wells are so great. These wells are so great. Wonderful. Let's get you paid more money. Let's get you paid more money because there's going to be better wells. Let's get you 15, 16, 17, whatever percent royalty, or maybe let's hold off. But again, this is not specific advice. It's advice saying, yeah, you want to look at your lease. You want to understand it. You want to know if you have acreage eligible to be released, whether by Pugh or depth severance, or maybe your lease even expired. Write the company. Get a lawyer. Write the company. Get that released because it may be a whole new opportunity to get a new lease. A new lease for the separate acreage that has been released because of the language you originally had that said, if you don't unitize it, release it. If you're not deep enough, you got to release it. All right, as often is the case, I'm up against my deadline here at the end of the show. I want to remind everybody, look, if you need help, you need assistance, you can always contact the office, 570-307-0702. Listen, look at your leases. If you don't understand, you want some help, we can do reviews and consults, usually an hour to 2 hours at tops, and we can find out, do you have the Pugh clause? Are you eligible to have acreage released? Do we want to get this acreage released? How do we want to handle it? Generally, you're going to want to, but we're here. We're here for landowners. Reach out. If you don't want representation, but you want information, PAGasleaseattorney.com, pipelineattorney.com. I've been much more active in writing blogs of hot topics that people should be aware about. Go check those out as well at the website, PAGasleaseattorney.com, pipelineattorney.com. And remember, we're going to be here every Sunday from 8 to 9 a.m. We're not giving up. We're going to keep giving information that you need. Have a great week, everyone.